this particular session on constitutional right to environment slightly differently. Instead of coming up with a lecture as to what is a constitutional right to environment, it is more like a question and an answer session. To break that monotony of a lecture, an attempt is made here to present the gist of this law in the form of answering a number of questions. The foremost question that should occur to the mind of a student after having heard the lecture so far on the constitutional space for allowing the communities and the local bodies to come to the mainstream of environmental governance, to have a role, responsibility, and a function to perform. The question that should be right up front to pose should be, does the Constitution provide for a right to environment? What has been the considered opinion of the Constitution makers when they made the central government, the state government, the local bodies, and communities as the managers, as the custodian, as the trustees, and as the stewards of environment? It still doesn't answer and explain whether an individual like me and you would also have a role to play, not just a role to play, but a right to demand. A right to demand as a constitutional right to environment. Is that there? And if at all it has been envisaged by whatever means, how it is actualized? That's the question. That's the question we shall currently address. In more specific terms, is there anything like a fundamental right to environment? For that, the straightforward answer is, in the text of the Constitution, no. There is no mention of fundamental right to environment. There is, of course, a mention of right to life under Article 21 of the Constitution, that each one of us have a right to life that should be protected unless and until the state, because of certain kinds of legal provisions, would have the power to end the life, my privacy, my liberty should be protected. So in the text of the Constitution, this is what has been provided. There is nowhere right to environment is mentioned. Then the question is, if it is not mentioned in the Constitution, why get into a discussion over that? But there has been a lot of talk about that. Okay, then in that event, is it only a private right? Or it is just an aspiration, not a right at all? But we have heard that the higher judiciary has started considering it as a constitutional question, isn't it? That in a number of cases, the Supreme Court has questioned about right to environment and has decided on that as very much closely related to human right. But then, even if it did, how could the Supreme Court state something which is not there in the Constitution? Why should the court accord the status to environment at all in the first place of giving me a fundamental right to environment when the Constitution makers did not, in their wisdom, in their considered opinion, did not think of making it part of the Constitution? Number of questions. So far unanswered by me. And let's find it out now. How do we approach this and how do we answer this question? As was mentioned earlier, Article 21 of the Constitution simply states, no person shall be deprived of his life or personal liberty except according to the procedure established by law. That's all. It is a fundamental right to life I have. Is it a fundamental right to environment? Not in the text of the Constitution. No mention, either in this provision or anywhere else in the Constitution. As a matter of fact, a Constitution Review Committee was constituted after about 25-30 years of the Constitution being put into work to review and then see whether some provisions of the Constitution, do they require some amplification, addition, amendment, reform, or some of them have become redundant to be removed. It was a committee headed by a former Chief Justice of India, Justice Venkatachalaya. Justice Venkatachalaya committee, in their recommendation, they came up with a number of suggestions. They did come up with a recommendation, not about right to environment. They came up with a recommendation to make right to water as a fundamental right. But it's more than 30 years since this recommendation has been made, and even now, this is still kept in the cold storage. That means what? It simply means the constitution makers in the first instance and the parliament in the second instance, somewhere late in the 1990s, even after receiving the recommendation of this review committee, did not choose to make right to environment as a fundamental right. In fact, what the parliament did was, about which we have already seen, that through the 42nd amendment, they made it a fundamental duty of every citizen of India, me and you, a fundamental duty to protect the environment, not a fundamental right over environment. So we only have a duty to environment as has been provided under the constitutional text. Okay. Then the question is, how is it that the higher judiciary refers to this as every citizen's right to environment? There are cases which we will be presently be reflecting on, and one case that I have mentioned at the top of the screen, the case of Subhash Kumar versus State of Bihar. In that, the Supreme Court, in very clear terms, look at the year 1991, every person enjoys a right to a wholesome environment, which is a facet of right to life guaranteed under Article 21 of the Constitution. These are the exact words of the Supreme Court. We are in a difficult situation. Here is something that the text of the Constitution saying, and here the court of law trying to read something into the Constitution. Can they do it? Is it not interference in the Constitution making by the Constituent Assembly or by the Parliament, which are only empowered to add, insert, or do whatever they want to do within the constitutional frame to the Constitution? Is it a case of judicial activism? Did the court assume to itself functions which was not there with it? But anyway, the court has said every person has a right to a wholesome environment, clean air, clean water, and all that. And it says that it is an adjunct of right to life, which is a fundamental right under the Constitution. So my right to life, under the constitutional guarantee of a fundamental right, meaningless if it does not have a right to wholesome environment as an attribute of this. This is what the court said. Can the court say so? Is it law of the land? How can the Supreme Court justify this? First and foremost, it must be stated the court was considering this aspect as well. Is it activism on its part? The court said nothing doing. We are not exercising a jurisdiction which we do not have. There is no activism involved. We are only performing the function assigned to us under the Constitution. Please look into the Constitution. Look to Article 142 of the Constitution. What does it say? Are we just a court of law resolving disputes? That people have conflicts, people have disputes, they come to us, we resolve the disputes. So the court of law's function is only to settle claims, interest, and conflicts, nothing more. Sorry, that is not what the Constitution says. The Constitution says that the highest court of law is not just a court of law, it is a court of justice. Not just that. It is not only the court of justice, it is the guardian of the Constitution. That means in the understanding, in the interpretation of the Constitution, in the application of the Constitution, the Supreme Court is the final word. Whatever it says, that is what is the constitutional intent and will. And as the court of justice, it has all the powers to pass any order, any decree, any judgment for ensuring complete justice is done. And we as the highest court, the Supreme Court says, we are just performing our function. Whenever there is any vacuum in the law, whenever the situation demands that the existing body of law or the existing understanding of the law is inadequate to meet the ends of justice, we are ordained, we are under an obligation to do complete justice, and for that we will give our own understanding of it, which shall become the law of the land. Anyway, this aspect is further developed in greater and detail, more in greater depth, in two modules we have reserved for your consideration on the role of the judiciary in developing environmental jurisprudence in India. We will discuss that in greater detail. Suffice it to say for the time being that the courts are not performing a role of an activist. They are performing their constitutional function, and in discharging that particular function, they have declared right to environment as an extension of right to life, which is a fundamental right. So what do we gather from this? All that we gather from this is, although in the text of the Constitution there is nothing like right to environment as a fundamental right, the judiciary has constructed that and has worked it into the fundamental right part of the Constitution. They have given a new lease of life to the right to life as a fundamental right by extending it to right to environment as well. But the question comes, why should the court of law take so much of pains and explain so many things as to say that we are performing only our functions? But why do you rank them as a fundamental right? What is so special about right to environment? And why accord the status of a fundamental right to it? Can you not make it just an ordinary legal right? Can you not just say that this is a concession that is being enjoyed by every member of the public? But why call it as an extension of a fundamental right? This is a question that makes us go a little deeper into this. And for that, we need to understand why rank this as a fundamental right or on par with a fundamental right? And what is so special about fundamental rights? How do you really view it as something superior to an ordinary legal right? And that's what we presently do. What is special about fundamental rights? The fundamental rights enshrined in our Constitution are there in Part 3 of the Constitution. A host of rights are mentioned. These are, as a matter of fact, constitutionally protected human rights. These are basic, inalienable rights of every citizen of India. They are more than an ordinary legal right. What do you mean? To be an ordinary legal right, if in a particular statute, if it is recognized or if it's mentioned that such and such a thing is a right of an individual, that I as the owner of a particular property I can occupy that premises, I can gift it away, I can sell it. Where do you find that? It is there in statutory formulations. So statutes give me that particular right. And so it is a recognition of my right, which is called as a legal right. But a fundamental right is not just declared by a statute. It is a right which is very much there in the Constitution, which gives additional insulation of protection. Not a statutory protection, but a constitutional protection. What is that constitutional protection? Protection in the form of the exercise of what is referred to as a writ jurisdiction by both the High Court and the Supreme Court. What is a writ jurisdiction? Writ jurisdiction is a jurisdiction or an authority exercised by the higher judiciary by commanding anyone, anything, any authority, any corporate body, any governmental agency, questioning their actions and asking them to see that the human life, limb, entitlement, rights are not violated in any way. How does this manifest? It manifests in a wide variety of forms, and I'm mentioning them. The first one is what is referred to as the habeas corpus. If somebody is detained by the governmental authorities, then if a petition is made that this person's liberty is being restrained unnecessarily, unduly, illegally, the court, looking at the circumstances, may exercise its power of a writ. It will issue a writ of habeas corpus in the government. Look, you, the government, first you produce the body, present it before this court. Then we will decide whether your detention of this individual is proper, just, legal. We will decide on that. So production of somebody who has been unreasonably detained is what has been provided under this. The second one is important and which is profusely used in most of the environmental litigations. It's called as the writ of mandamus. Mandamus or a command. A command given to an authority. That you as an authority in a particular problem situation, you have acted in a particular way and we command you, we give you the directions that instead of having done whatever that you have carried out, undo that or do it differently or do it in a particular way as we prescribe and report back to us. It's a command given to an authority. That means over an administrator, the court sits as a super administrator, provided under the Constitution as a super administrator to command them to do a number of things, giving directions to them as to how to behave. On a particular environmental issue, you have acted in a particular way. No, you need to act in this particular way as we prescribe to you. And that would be the ends of justice. Or, in certain circumstances, certain actions are taken by the authority. And these actions are questioned. The one who is questioning the authority of the government is not too sure which law actually supports the decision of the authority to act in a particular way. But I, as an individual, or the one who is bringing in this action, is not the one who has the power of asking this question. What he does, he goes to the court of law and submits before the court. Your Lordship, we believe that this particular authority has acted not in accordance with law. And that is the reason why we bring in this particular action in public interest. Then the court would issue a quo warranto. Quo warranto. Under what authority you have exercised this power? Justify, and if you cannot justify, roll it back. Put it into a status quo at a position. And similarly, there are other writ jurisdictions like writ of prohibition, prohibiting a particular action, or a decision which is patently illegal or void or unjust to undo the damage that has been done through what is called as the writ of certiorari. Like that, these are the weapons that are there in the hands of the High Court and Supreme Court. Whenever individual liberty or a right is affected, it can act. This has been used profusely on environmental issues as matters of public interest, and writ jurisdiction is very much there for the Supreme Court under Article 32 and with the High Court under Article 226 of the Constitution. And this is exercisable even against the government. A statutory right is a right that you exercise against an individual, a private right. But this is a right which is a constitutionally guaranteed right. It can be exercised even against the government. So government is not all that powerful. Government is an extension of governance. Government is a device or a tool which has been entrusted with the responsibility of managing the affairs as an operative tool of governance. And people have the right to question, challenge every action of the government like this. It's a powerful right. But then the question remains, all that has been mentioned here, what has been mentioned in Article 32 is part of a fundamental right. So to pursue that fundamental right, through the intervention of the higher judiciary, you exercise the writ jurisdiction. So we are referring to an individual right, but why use it for environment? When the concerns over it are not confined to one or just a few individuals. Why not be satisfied by the power of whatever that is there in the ordinary law, power of injunction at the primary judiciary level? Is it not a power that is there with the local courts, the trial court, the district court, whereby they can give an injunction? Injunction is either asking somebody who has put an obstacle to remove that obstacle, or when a damage has been done, to repair the damage, correction, or an injunction not to interfere. This is what is available in ordinary law. Primary judiciary can act, but why go to High Court and Supreme Court and that to an individual right, claim it as a right in relation to environment? These questions are not answered yet, although a particular level of an answer that to meet the ends of justice, the court can interfere on environmental issues. But why rank them as a fundamental right has not been explained. The explanation comes like this. It is there in a plethora of case law decided by the Supreme Court that whatever that we have under the environmental legislations, the remedies available are statutory remedies. They have limitations. There are exceptions to the exercise of those remedies and claiming those reliefs. But in the case of right to environment, as has been declared by the Supreme Court, those limitations of a statute are not there. Second, we have environment related laws enacted for the last 50 odd years, but is it not our experience that the administration has not been able to make an impact in addressing all environmental issues, all environmental problems in an effective way? Had they done it, we would have had a better environment, less pollution, less contamination, and hardly any waste. But we have all these problems still there, in spite of a robust administrative machinery, in spite of a very strong legislative framework. So there are limitations into the working of these laws, and so we need to elevate it to the status of the Constitution. And no better agency other than the court of law which can do. And here the role that is exercised or performed by the primary judiciary is inadequate. They only give an injunctive relief, if at all that is there in a statute. If it is not there, no relief. In that event, you need to really treat environmental conditions far different from an ordinary inconvenience, an ordinary irritant, or an inconvenience of a nuisanceable kind, but something much more than that. And that's what the higher judiciary has done. They have considered environmental concerns as far more important than addressing and adjudicating upon violations over ordinary legal rights. There is public interest involved. It is not only affecting an human being alone, an individual life, but the lives of many more. And it is not just the life of human beings alone, but that of human and non-humans as well. So it is a national interest. Who says that? It is the Supreme Court said that. In the year 1994, in a very interesting case concerning a national park, the Sariska National Park in the Rajasthan state, a case entitled Tarun Bharat Sangh Alwar versus Union of India, the Supreme Court stated like this. They invoked from the Chanakya's Arthashastra this particular statement. Look at this. If the interest of the family is affected, the interest of an individual can be sacrificed. But if the interest of the community is affected, the interest of a small family may be sacrificed because the communitarian interest is superior to the familial interest. But if the interest of the state is affected, community is only a subset of the state, the subset of the society at large. And so, for meeting the larger interest of the state, larger interest of the nation, the communitarian interest can be subordinated. And finally, when the environment is affected, forget about the individual, forget about the family, forget about the community or even the nation, because environment is far superior to a nation. Who said that? Chanakya's Arthashastra. Environment is above all. Their concerns, protection, conservation is far superior to that, because without that environmental resources, there is no question of an individual, community, or the nation. It doesn't exist. And so, environment takes the top priority. Environment is above all. And that is exactly the reason why the higher judiciary is concerned about that, not because an individual is an inconvenience, but because it is a larger interest, the very survival, sustenance, and development of human and non-humans involved. And so environment should take the top priority, and no better agency than the court of law to address and accommodate that. And that's why through a judicial construct, it is raised to the level of a fundamental human right. It is also raised to the level of a public interest, and so the writ jurisdiction is excised. There is nothing like the court of law acting as an activist. The court of law needed to see that justice is done to the environment. Without that, there cannot be anything like human existence or human survival or anything to subsist on earth.